Now we are moving to the next presentation, and I think nowadays we have professional doubles, so always two people you have on one side. So Professor Stanković and Tuhtan Grgić will talk about the report interest in and procedural cost and limitation of liability.
Before we proceed, do you remember the last of the four, the last slide on the issues presentation? There were 4 emblems. Do you remember the third one? The third one was probably the portrait of the current president of the Croatian American law. Super. You are probably asking yourselves, what the hell are these people doing in a session which is hardcore collisions? I mean, they are intruders. Get them out, please. But there are at least 2 connecting factors with the topic of today's presentation. One is that, as we know, Professor Grgić was an all-around maritime lawyer, not only dealing with collisions, and to our knowledge, limitation of liability was one of the topics that he was quite fond of. And the other reason is that the case that triggers this presentation actually has to do with not with a collision but with elision, and there is some connection as you will see. And so we decided to spice up this morning's session by something different than collisions at sea. Each of the institutes that we are dealing with, in fact, broadly speaking, has its protective function. So the protective function of the limitation of liability is to protect the ship owner or other participant in the shipping business who incurs liability. But in essence, it's protecting the liable part. Default interest protects claimants who have pecuniary claims against unwillingness or delay by the debtor to pay the pecuniary claim. And procedural costs protect, let's say, the winning party to the court proceedings, and winning sometimes or very often means innocent. So the purpose of this presentation is to see how these 3 are related in the context of the limitation of liability, or proceedings relating to the limitation of liability. These are the facts of the trigger case. Very briefly, in 2018, ship in the process of berthing collided with the port installations, damaging them and causing damages not only in terms of physical damage, but mostly in the form of a loss of profit to a number of claimants. Very shortly afterwards, the ship owner constitutes the limitation fund. We are talking about the case going on in one of the Croatian courts. And more than 20 claimants have filed their claims against the fund. And the total of those claims significantly exceeds the limitation amount.
Yes. Is it possible to remove that black line?
If Misho couldn't, I definitely can't. Because he's the IT guy.
Intelligence.
Yeah.
You can just move it with the mouse. Yes, just move it.
Just
mouse.
You manage it with the mouse. if somebody has the guts, which I don't.
May have the guts because I'm not the speaker, right? Maybe.
Great. One. Thank you very much. In Croatia, as part of the limitation proceedings, the court has to hold a hearing for the purpose of examining the claims. And at that hearing, the ship owner has disputed all the claims altogether. So all the claims are disputed, all 20 plus of them. According to the Croatian rules, the court has therefore directed all the claimants whose claims have been disputed to commence litigation proceedings to justify the existence and the amount of their claims. That's because, as you all know, I guess, the litigation proceedings don't deal with the merits of the claims. So if there is a dispute as to whether there is whether any of the claims is valid, that's not something for the judge in the limitation proceedings to do. And this is where we stand now. 5 years after the incident, we have 20 plus litigation proceedings going on, neither of which has been completed. And in only one of them, we expect the first instance judgment to be issued soon. Of course, whenever the judgments are issued, there will be appeals, and the appeal proceedings usually take quite a lot of time in Croatia, with the outcome that's absolutely impossible to predict. So, if we can talk about the financial implications for the owner, he is at ground zero. I mean, he has established a fund. He is defending his position in all those litigation proceedings. It's different with regard to the financial implications for the claimants, because they cannot hope to get any money in due course, and their costs keep accruing. And given the amount of the claims, the costs are considerable. And here is where I step down and give the floor to Eva. I'll come back.
Thank you, Gordan. Thank you for choosing this topic. I find it really interesting, and it gave me a headache actually, because I have to put the slide back. The financial implications for claimants, it seems so unfair to me. The conclusion is that they're going to bear the cost on the people's interest, and I've decided to find why such a solution was provided in LLC and is really the only possible solution. So we are going to analyze two questions. What is the role of people's interest in constitution of the limitation fund? This is the first question. And then I'm going to continue with the question whether people's interests are recoverable, and if they are recoverable, whether they are recoverable from the fund or from the other assets, and what is the status of default interest in the distribution. So, pursuant to the Article 11 of the LLC, the liable person is obliged to pay to the fund the amount of the limited liability increased with interest thereon from the date of the occurrence giving rise to liability until the date of constitution of the fund. The first question is whether this amount of interest, so the interest from the date of the occurrence until the constitution of the fund, actually constitutes a fund as a composite whole, or is it an additional part of the fund and therefore available only for the payment of the interest? During the preparatory work, it was stated that that interest component actually makes part of the fund. However, in the recent case, in the Norwegian Supreme Court, full city case, in the limitation in fund proceedings, it was ruled that the interest components actually are not the part of the fund at all, but they form a supplementary part from which only the interest can be paid off, because if otherwise, if they were making the whole, then in that case, the limitation and the liability would be increased. So, and I agree with that conclusion of the Norwegian court. I agree that we have limitations and that we have additional fund that is that should be used only for the compensation of interest. This is the very first question. The next one, which is very important, is you can see that in respect of interest, LLC actually prescribes very restrictive calculation period. It says from the occurrence giving rise to liability until the constitution of the fund. So the question that rises here is why not calculate default interest throughout the period, so from the occurrence giving rise to liability until the actual payment of the out of the limitation fund. And to answer that question, so to see what was the ratio of this provision in LMC, we're going to go through the preparatory work. And then the other question is what actually happens to the default interest that occurs after the limitation fund is constituted, so following that moment. In order to answer the ratio of that provision of Article 11, I went through preparatory work, and I saw that the first draft of the Article 11 of the LMC, likewise the first convention and the second convention of 1924 and 1957, actually did not contain a provision on default interest. And during the drafting of the convention, it became clear that there are different solutions in different countries. There was a group of countries, Scandinavian countries, which actually had explicit norms prescribing that default interest as well as procedural costs are not included into the fund, and they're not limited, so they have to be compensated. Second group of countries were the countries where courts came to the same conclusion even without the explicit norm. And the third circle of countries were countries where the courts came to the conclusion that both the interest and the cost, residual cost, should be paid out of the limitation fund. So what was the result of this drafting? It was clear that it is impossible to find the solution that would be acceptable for all. And therefore, we had a minimum consensus. The minimum consensus was the one that we have in the Article 11. And this is to include those interests from the date of occurrence giving rise to liability until the date of the constitution of the fund. That was a proposal based on the convention for the inland transport in Geneva Convention. Article 11 is the only article prescribing or mentioning interest, and there is no article mentioning procedural costs. The second article of the LMC, which is important, is that all the rules of procedure shall be governed by the national law. So that was a compromise. All states have right to decide in which way to deal with those questions. What I want to say here is that the Norwegian representative underlined that there are numerous questions that remain open, and he underlined that it is necessary for states to prescribe how to deal with interest and procedural costs. So I'm underlining those. He said those questions must be answered by the national law, and we will come back to that advice later. So this is the historical background of the Article 11 of the LLMC. What is the Croatian Maritime Code that's written in the Croatian Maritime Code? Croatian Maritime Code is aligned with the LLMC. So there is a provision of the Croatian Maritime Code reproducing the Article 11, which, apart from this part on the interest, says that fund is only available for the payment of claims for which the limitation of liability can be invoked. Then there is a provision of Article 398, which is actually the Article 13 of the LLMC Convention, prescribing bar to other action, and thus making the fund, once constituted, being the only asset from which claims can be settled. Those provisions, in my opinion, do not mean that interests have to be compensated from the fund. And I think that was made clear even during the LLMC, because they said those questions are not regulated by the convention. So you are free in your national law to regulate them. So now the Croatian Maritime Code, the only provision that is contained differently than the LLMC is the Article 408, where it provides that within the part governing the limitation of liability procedure, it states that interest on timely notified claims shall accrue from the date of the constitution of the fund, and interest on other claims from the date of their notification. This means that actually under Croatian law, creditors are not deprived of the possibility to recover not only claims, but also the interest accrued following the date of the constitution of the fund. However, the question is whether those default interests that accrue after the fund is being constituted are recoverable from the amount of the fund, or from the other assets of the liable person. Unfortunately, Croatian legislator did not hear the advice given by the Norwegian government, Norwegian representative, and there is no provision in Croatian Maritime Code that would give us an answer whether those interests should be paid out from the fund or from the other assets. But let's try to find some arguments for both ideas. Why should default interest be recovered from the amount of the fund? So the first, it is the general rule that the claim for default interest is actually inseparable from the main principal claim and forms a single entity with it. And it is therefore logical that it follows the path of the main principal claim. And this is general rule. And if we take this argument, then it's clear that default interest should be paid off from the amount of the fund. There is also the argument contained in the Article 298 prescribing bar to other actions. However, there is also a number of arguments in favor of the second solution, saying that those default interest should be paid off from the other assets of the liable person. So the first thing is that the limitation of liability limits the liability. And the liability is prescribed for those explicitly enumerated occurrences in Article 2 of the LLMC. And being able to limit liability is already a privilege for the owner. And if he has the privilege to limit his liability, allowing him additionally to limit his obligation to pay default interest and cost seems, at least to me, too much in favor of the shipping industry. It is true that the interest accrued as a result of the late payment of the main principal claim. However, they are not consequence of the occurrence, which is giving rise to liability. They are actually consequence of the fact that the main claim is not paid at time. So it is interests are not listed in this Article 2, which is actually listing all the claims for which the liable person can invoke liability. What else goes in favor of this, this statement? In cases where the amount of damages is already higher than the limitation fund, as it's in our case, such conclusion would further reduce the proportion in which those claims would be paid out from the fund. And again, the balance that was meant to be done by this LLMC on one side of the ship owner and the other side of the other person is not in balance anymore. The fifth thing, and then if we have a liable person who already has a fund which is limited for his liability, he might be even encouraged to engage in lengthy litigation, and this is an argument why interest should be paid by the liable person. The last thing that has to be said is the insurance coverage. As it was mentioned earlier before, there is European directive on prescribing insurance for maritime claims. There are also recommendations for the insurance at the international level, and it is actually important to see that those costs are covered by the insurance and not by the owner or by the liable person. So he doesn't have to pay the claim, and because the insurance company is going to pay for that, and now he doesn't have to pay for the default interest and doesn't have to pay for the procedural costs as well. And this seems really unfair for the person who is victim. And last maybe to say is that we have to be very, we have to think twice when we want to apply general rule and claim for interest is inseparable from the principal claim to the general rule on the process, on the proceeding that is special. Limitation of liability is an exception from the general rule of restitution and integrity. So we have an exception, and applying general rule to exception leads, in my view, to very unfair conclusion. So it would be, I think, not in line with general principles of law. We're coming back to the Norwegian advice we should change, and Gordan is going to explain in which way and continue. Yeah, thank you.
Thank you very much, Eva. Mind you, we are not talking about small money here. The rate of interest in Croatia is, I believe, default interest at about 11% per annum. So correct me if I'm wrong. So you know, within several years, the interest is going to continue accumulating, and it's going to exceed the principal amount of all the claims. So it's, you know, the claims plus interest are going to be double or even more than original. And costs, you know, they are insubstantial amounts when the claims are big, and claims are big here. So, you know, we are talking about big money, and we are talking about who is going to pay this big money, whether the ship owner from the fund or otherwise. When we come to the matter of procedural costs, we have two categories of costs. One is the procedural cost in the limitation proceedings as such, the proceedings for the distribution of the fund, and the cost in the litigation proceedings that are ancillary to the limitation proceedings. In other words, all those litigations to which the claimant has to go in order to establish their claims. So there are two types of proceedings and two categories of costs. With regard to the procedural costs in the limitation proceedings as such, the Croatian maritime law says that each party to the limitation proceedings bears its own costs, which is quite problematic because, you know, why should I, as a claimant, wishing to get my claim or the part of my claim paid out of the limitation fund be bearing my costs of getting paid if somebody else has caused me damage. So it's, you know, it's very problematic in principle. It's quite outdated because Croatia recently passed its new law on non-contentious proceedings, and the limitation proceedings are considered as non-contentious proceedings. And this new law on non-contentious proceedings provides that costs follow the event. So now, if you have caused costs to the other party, then you have to pay those costs. So I think we have good grounds to amend the Croatian Maritime Code. What about the costs in the ancillary litigation proceedings? What are they? They are litigation proceedings to establish the claim. According to the general rules of litigation proceedings, the costs follow the event. So the losing party pretty much has to pay the procedural cost of the winning party. So what happens if I, as a claimant, win the litigation and the costs are adjudicated in my favor? The same two questions. Are those costs paid out of the fund, or can they be also paid out of other ship owners' assets? And if they are paid only out of the fund, are they paid from the original substance on the fund, or do they have to be added to the original limitation figures by way of supplementing the fund? And here we have pretty much similar reasons as with regard to the default interest. We have Article 13 of the LLMC, which says, you know, if the fund has been constituted, you cannot get paid from anywhere else but only from the fund. It would be, they say, it would be illogical if you could get your costs from other assets of the ship owner and in full, whereas you get your principal claim only from the fund and only up to a certain proportion, which could even, they say, undermine the main purpose of the limitation of liability. On the other hand, let's just see what the leading authorities say. The states are more and more in the favor of excluding the costs from the limitation fund. Some think that the fate of the costs should follow the fate of the claim if depending on whether the costs are or are not a part of the claim. According to Martinez, the costs are a procedural matter, and all the claims subject to limitation are a substantial matter. So we should not be mixing substantial and procedural matters. As was already mentioned with regard to the default interest, if the cost were to be satisfied only from the fund, the ship owners could be encouraged to embark upon lengthy litigations just to twist the claimant's arm and get a better deal. So, with regard to the first question, my answer now is that it is at least not clear whether the cost should be satisfied out of the fund or can also be satisfied from other ship owners' assets. If it would be correct that the cost could be satisfied only from the limitation fund, then another question, the second question kicks in. Are they satisfied from the original amount of the fund, or is there a supplement to the fund, like in case of default interest? Here we have Article 9 of the LLMC, which says that the limits apply to the aggregate of all claims which arise on any distinct occasion. But claims do not include costs. Claims are claims. If the costs would be satisfied from the original limitation figures, it would again open the doors for the ship owners to embark on lengthy litigation. And the Croatian Maritime Code contains an interesting provision which says that when constituting the limitation fund, the ship owner has to advance a sum needed to satisfy the cost that will accrue during or in relation to the proceedings. That is a clear indication that costs are to be added to the original limitation figures and constitute a supplementary part of the limitation fund. Also, we should not lose sight of the fact that with regard to the default interest, the LLMC clearly says that the default interests are supplemented, are added to the original amount of the fund. And at the end of the day, the rules on limitation of liability should be construed contra preferentum, which means in favor of the guys who are less privileged. And of course, the claimants are the less privileged guys when it comes to the limitation of liability. And let us just have a brief look in what some other conventions have to say about interests and costs. Take, for example, what the Athens Convention says. It says expressly that interests and legal costs are not included in the limits of liability. Fair and square. Montreal Convention contains even a more interesting solution. Basically, it says that the claimants have the right to receive interest and legal costs if the amount finally adjudicated in their favor exceeds the amount that was offered to them by the liable party within the first 6 months. Maybe we could use some of those ideas in our future considerations with regard to the limitation of liability. Thank you very much.